The statement made before the police officer, section 162, restrain those statement, prohibit those statement for be used for any purpose. And the section 25 come between that area, that when in the police custody or when you are before a police officer, in that statement you admit the guilt. So when you make the statement and in that statement amount to the confession, then that confession is also not admissible. So section 25 is basically in line with the section 162. Okay, section 25 and section 162 are, you know, you can say in the drafted in synchronized manner. So that also we have discussed. Now come to the section 26. Today's lecture we will discuss section 26 and section 27. As earlier also I said that section 25, 26 and 27 makes one group that can be discussed, that must be discussed in one, at one hat, because section 27 is an exception to section 25 and 26. Section 26 is extension of section 25, but the scope of section 25 and 26 is distinct. And section 162 also we read in our last class, because section 162 in the CRPC impose a ban or prohibit for signing the statement made by any person to the police officer. And the second thing, it cannot be used for any evidentiary purpose. And so in that direction, section 25 is drafted. But section 26 is not something that is made to the police officer. Section 26 area is different from section 25. Section 25 and section 162 only prohibit the statement made to the police officer. That statement cannot be used. But section 26 talking about that the statement that amount to the confession, even if it is made to some other person other than the police officer. Now the question is, who can be such person? Maybe the doctor, maybe the fellow prisoner, maybe the visitor. Like, see, try to understand, to simulate the situation, that there is person A and he is accused of the rape. Now, because he is accused of the rape, and so there is medical examination has to be done of that person. And for that medical examination, when the person is bring to the hospital in presence of the police officer, because at that time he was in the custody of the police officer. So in the presence of the police officer, he bring to the hospital, and in the hospital he confessed, he made the confession of his guilt before the doctor. Section 25 will not be applicable because the confessory statement is not made to the police officer. Section 26 come into the picture. If he made the same confessionary statement to his fellow patient, then also, again section 26 come into the picture, and there is no role of section 25. And so these instances I told you just to clarify that the scope of the section 25 is different from the scope of section 26. Okay. Now come to the reading of section 26. You all have barracks and try to read this section along with me. Section 26, confession by the accused while in custody of police not to be proved against him. This is the marginal note. No confession when a particular provision start with or couched in negative connotation. That means the ban or the prohibition it is imposing is of the greater degree. No confession made by the person whilst he is in custody of police officer, then I'm leaving that line, shall be proved as against such person. Now, if you convert this negative sentence into the positive sentence, it would be like the confession made by any person while he is in the custody of police officer shall not be proved as against such person. So, section 26 is not talking about the, you know, that it is irrelevant or relevant because it's not dealing with the question of voluntarily and non-voluntarily. It may be the voluntarily that after the arrest, due to the accused is prompted by his conscience and he made the confession before the doctor. He said, "मेरे से तो बड़ा अन्याय हो गया." But because there is a public policy, there is an inherent danger, and so such type of the confession that is made by the person while he is in the police custody. He is in the police custody, he is in the custody of the police officer, is declared to be inadmissible. Not to be proved means inadmissible. Cannot be proved. Admissible nahi hoga. And then in this section, there is the line that unless it be made in immediate presence of the magistrate. So that is the, problem shooter. That only in one situation the confession made by the police officer, confession made in custody of the police officer can be, would be become admissible when it is made in presence of the immediate presence of the magistrate. Now, in the explanation, the word magistrate has been also clarified that magistrate means the exercising the power of the magistrate under the old criminal procedure code 1882. And magistrate does not include head of the village that used to discharge the function in the presidency of the Fort St. George. Earlier there used to be three presidency of Bombay, presidency of Kolkata, and the presidency of Chennai. So there, that area has to be ruled in the presidency, and the rest of the area is known to be Mufassil area. So at that, in that presidency area, certain power has been given to the village head. So that village head would not be treated as a magistrate. So that only. So that is just a clarification that who will be magistrate. Now the important thing here is that first and the only thing is that what is the scope of this phrase that in the custody of police officer. What constitute in the custody of the police officer? Whether only holding or whether he is in handcuff, that amount to the custody of the police officer, from where the custody of police officer started. So this is the important question. Other things are, crystal clear. Now, if you see the purpose, the policy on which this particular section is drafted, is to prevent the abuse of power by the police officer. There is fear in our legislature that police may use its powers to force a person to confess. And so this fear is present only when the person is in the custody. And so, in that sense, in light of that policy, we have to interpret the phrase in the custody of police officer. We cannot interpret it is in the strict sense. We has to interpret in the liberal sense. So, to give true meaning of the intention or the fear of the legislature, whenever we have the doubt that this amount to the certain fear, he is not free, and so that would amount to the custody. When he is taken to the hospital, the police officer was sitting outside, they are standing outside, and the doctor is examining. Though the doctor is examining, but in the fear of the accused, there is still that he is in police custody. Though the police officer was not handcuffed, that person was not holding the hand of that person. So that in that sense we have to, because the object of this section is to prevent the abuse of the power by the police under this section. Now, why to exclude the confession made in the presence of magistrate, in the immediate presence of magistrate? That means still the person is in the custody of the police, but the magistrate has come. And this is because the confession is always is relevant if it is free and voluntarily. And when the magistrate is present, the emergence of the magistrate secure the free and the voluntary nature of the confession, and the confessing person has the opportunity of making confession uncontrolled by the fear of the police. And so, in that light, it has been excluded by the section 26. Now, under the NDPS Act, narcotics and psychotropic substance, the confession under their revenue intelligence officer was not to be hit by section 25, because Supreme Court has declared that these officers under the NDPS Act are not police officers. But that does not mean that the court has to freely and heavily relied on that. The confession must be subject to the closer scrutiny than a confession made to the private citizen or the official who do not have the investigating powers. And these revenue intelligence, Department of Revenue Intelligence officers, though would not amount to the police officer as per the section 25, but still there is doubt that fear may have caused in the mind of the accused. So that sense. But strictly section 25 would not make those confession as inadmissible. But the judicial scrutiny, or the with the greater scrutiny, these confession has to be seen. Now, in our last lecture also I told that suppose in the immediate presence also the confession is made to the police officer by the accused. So section 26 would not cover it, but section 25 would come into the picture. And section 25 always prohibit the confession made to the police officer. And the police officer, not only to the police officer who is investigating, police officer means to any police officer, whether he is investigating or not investigating. So that is the thing. Now come to the meaning of the phrase that in the custody. As we have discussed, that if we see in the light of the intention of the legislature, the fear that they have in their mind, and that's why the section 26 is drafted. In that line, the custody word used in the section 26 and the same word used in the section 27, and both the word has the same meaning. A formal accusation of arrest is not necessary to constitute the custody as understood in section 26 or 27. A person is in the custody from the time when he is either as an accused or a suspect. Maybe he's just a suspect, come into the hand of the surveillance of police officer, or during the investigation, if you have seen many movies, that there is some doubt. There is one movie, web series I have seen, The Sunflower. In that Sunflower, there is a doubt on many persons. There were many suspects, and the police officer have warned them that you have not to leave the city. So where the person is under the surveillance and the police officer warn that cannot leave, it is sufficient if the state of the affair is such wherein the accused can be said to have come into the hands of the police officer, or can be said to have been under the surveillance or the restriction. He will be deemed to be in constructive custody if he is not permitted to depart from his own free will. So the custody may not be legal. Even the temporary absence of policeman or the guard does not make that the person is free from the custody. And so the confession of the guilt to the another patient, while in hearing of the doctor, the police officer waiting outside in the veranda, was held to be a confession made by the accused while he is in custody of the police officer. So the liberal meaning has to be given to the word in the custody of the police officer. When the person is accused or the person is suspect under the surveillance, he is not free to go or to free to leave. In that situation, it is deemed to be in the constructive custody of the police officer. Now, why this liberal meaning we are giving? Just to, interpreting the section according to the intention of the legislature. Statement made by the accused to the doctor of the government hospital, though incriminating, and where the police officer are present, not admissible. So that is the meaning or the scope of the word in the custody of the police officer. Now, if you remember R.K. Malkani case, the coroner is the person who has power to do the inquest. Inquest means to examine the body and to find out the causes that how that person has died. And so a coroner is a magistrate because section 20 of the Coroner Act 1871 Now, there is another thing that during the police custody, whether the making of the confession, whether it would be something that is covered by section 8, whether that would be a relevant fact and admissible or not, because that is shows the subsequent conduct. Try to understand the situation that there is a police call and the police has reached to the crime scene and the suspect was arrested, that this is the person who raped this girl. So in the offense of rape, two things has to be proved by the prosecution. One is the sexual intercourse by this person, and the second one that it was without the consent of the lady, or some other situation that you have read in section 376 of the IPC. With respect to the first thing, that she was not consented, there is the presumption, so the burden has shifted to the accused. But with respect to the sexual intercourse, that has to be proved to constitute the offense. So there is the something that medical examination has to be done. In the medical examination, they will even write the injuries on the parts, private parts of the accused also, or some other situations, and then the semen is collected and for forensic examination. And during this, when this person is transporting to the police, by the police to the hospital, in the hospital, he made this confession to the doctor. Now, if you see the section 8 that talk about the previous and subsequent conduct, now this confession is amount to the subsequent conduct. But because he is in the police custody, the constructive police custody, though the police officer are standing outside the room where the examination is conducted. And so, what is the scope of section 8? Section 25 and 26 are not controlled by the section 8. Section 8, so far as it permits the proof of the statement as a conduct, must be read subject to the section 25 and 26. So section 8 has to be read subject to the section 25 and 26. So that is. Now come to the next section, section 27. How much of the information received from the accused may be proved, provided that, and when this section is started with the provided, you have read many sections, many provisions, the main provision and then the proviso, provided that. That means in that particular situation, the main provision will not applicable. It is just an exception. So from the first word itself, you can infer that section 27 is in the form of exception. Provided that when any fact deposed to as discovered in consequence of information received from a person accused of any offense in custody of police officer, so much of such information, whether it amount to the confession or not, as relate distinctively to the fact thereby discovered, may be proved. So it says that as much, whether it amount to the confession or not, when it does not amount to the confession, that means statement short of the confession or subordinate statements, those statements, there is no problem. But in light of the judgment of Agnu Nagesha versus State of Bihar, that if a confession or if a statement has both exculpatory and inculpatory part, then whether we have to read it as a whole or to exclude it as a whole. And in that light, certain portion of the statement cannot be used. And so, like the confession under section in the Agnu Nagesha case, hit by the section 25, and so it has to be excluded as a whole. Now, section 27 is giving the hope that in that confession, that portion or that fact that is discovered in consequence of the information received by the person and relate to distinctly to the fact thereby discovered, so that may be proved. Now use this thing in the Agnu Nagesha, also in the last para that we have read in last class, that in the first information report itself, he narrated the whole story, that how he killed all the four deceased and why he has killed, and then that he has hid the dead body there, the weapon that used, the blood stained chadar, etc. And on that also it was found. So in this whole confession, on this statement, this particular fact is discovered, that the accused has the knowledge where the dead body was lying. The accused has the knowledge where the offense, where the weapon of the offense was hidden or was lying. Only that much of the portion can be used. So that giving the scope. Now section 27 is also not free from the litigation. There are so many litigation. Section 497 of the IPC. Can anybody tell me what is section 497? Yes, guys. Adultery. Very good. Section 499. Yes, anyone? Yes, please. Section 499. Yes, good, Arshad. Good work. Section 377. Homosexuality. Not homosexuality, it basically covered to unnatural offense. Yes, punishment. Yeah. The purpose is that these were the some of the provision which were challenged in the court about their constitutional validity. Section 377 was also challenged, and it was held that the portion where the two consenting adult have the sexual intercourse, that means the situation of homosexuality, to that much of the portion is violative of the constitutional provision, unconstitutional, but without the consent having the unnatural offense is punishable. So declaring only or partially declaring unconstitutional section 377. Section 497, still it is in the statute book, declared unconstitutional. Section 5499, Subramanyam Swamy has challenged that it is unconstitutional, but the Supreme Court said that no, it is upheld the virus. Because if you see the defamation law in India and in the United Kingdom, we are following the British rule. All the law has been drafted during the British period. There in the Britain, even there is the deliberation that whether the defamation has to be repealed as a civil wrong or not. There it is not a criminal wrong. Here it is criminal wrong as well as the civil wrong. Criminal and civil action for compensation both can be taken. There the discussion is on that we have to even remove it from the civil because it have the chilling effect on the freedom of speech and expression. But unfortunately the Supreme Court has declared that section 499 read with section 500, that means the punishment in section 500 is not ultra virus. Section 303. So similarly, there are many, section 66A of the Information Technology Act. So there are so many provisions where the bias has been checked by the courts, the constitutional courts. And similarly, the section 27. The section 27 also not that it has been always appreciated. It has been challenged. The two cases. In the first case, it was challenged that it is in the violation of the section 14, article 14. And then another case, it was held that the section 27 violate the principle under article 20 clause 3. In the state of Bombay versus Kathi Kalu Ogad, state of Bombay, you can write also STATEVOMBAY, state of Bombay versus Kathi KATHI, Kalu KALU, Ogad OGHAD, 1963 1 SCJ 195. And here it was challenged that the section 27 is ultra virus, is unconstitutional because it violate article 20 clause 3 of the Constitution. It was contended that section 27 offend against the protection guaranteed under section 20 clause 3 against the testimonial compulsion. But the Supreme Court held that no, section 27 is not unconstitutional, and the reason has been assigned that compulsion not being inherent or implicit, the fact of the information having received from a person in custody, the contention that section 27 of Evidence Act necessarily infringe the article 20 clause 3 of Constitution cannot be accepted. Chief Justice Sinha observed that whether compulsion was used or not will be a question of fact in each to be determined by the court on waiving the fact and circumstance disclosed in the evidence before it. And so the contention that police use the compulsion, Chief Justice Sinha said the compulsion is the question of the fact. If you contend that in my confession the force has been used, so maybe that portion that section 27 allowed would also be hit by that. Otherwise, as such, it cannot be treated as unconstitutional. Then earlier, section 27 was held to be that it offend the Constitution, Article 14. Article 14 talk about equality and equal protection of law. It says that section 162 of the CRPC, section 162 of the CRPC prohibit that the statement made by a person, statement made by a person to the police officer, no part of that statement can be used for any evidentiary purpose. Now, when the person is not in the custody and he make a statement, then even by that statement, if something is discovered, that would not be admissible and cannot be used. But when the person present in the custody, then such portion of the statement that relate to distinctly to the fact, and this statement would be proved, would be admissible. So the person who made the statement outside the custody and the person who made the statement in the custody, there is the difference in the protection provided to these two persons. And so it is violation of the principle of the equality under Article 14. High Court ने मान भी लिया. The High Court, Allahabad High Court, upheld this contention and declared that Section 27 to be void as offending against the Article 14. Then it was appealed to the Supreme Court. And in the Supreme Court, in appeal, the contention was negatived, held that the classification between person in custody and person not in the custody was manifestly reasonable and refused to strike down under Section 27. And the name of the case or the year in which this case was is QE versus Nana, or you can find this case was from 1961 to SCJ. Now, with this, both the litigation has lead, but our Section 27 is still there. After two successful attempt to strike down Section 27 is still there. In Devman Upadhyay case, that is also one famous case, there was the discussion with respect to the scope of Section 27 with Section 161 and Section 162 of the CRPC. And it was held that the amendment of Section 162, that nothing in this section affect the provision of Section 27, has now set as the old conflict at rest. Section 162 of CRPC also enact the rule of evidence by combined operation of Section 27 of the Evidence Act and Section 162 of CRPC. The admissibility of evidence against the person in criminal proceeding of the statement made to the police officer leading to the discovery of a fact depend for its determination on the question whether he was in the custody at the time of making the statement. It is proved if he was in the custody at the time when he made it, or otherwise it is not. And so this controversy was also set. In Section 162, you will find clause 2, that talking about that nothing in this section shall be deemed to apply to any statement falling under the provision of clause 1 of 32 or affect the provision of the section 27 of the act. So that thing is also settled. Now come to the main or the important thing, that is what is the scope. Here the distinctly means very different or new. Here section 27 basically make those statement admissible that result into the discovery of a certain new fact. The discovery of the certain new fact, if the accused said that I have stabbed by the knife to the deceased and the knife was hiding in my house. This is not the discovery of the knife. The knife has been already discovered. This is the discovery of the fact that the accused know where the knife was hidden. So that is the thing. And on which there are two cases in our case material. Agnu Nagesha was also the case in that line. The next case is Pulukuri Kottaya versus Emperor, AIR 1947 PC Privy Council 1947. 2 minutes I will take. On the first para, there is the case history, that how this case has reached to the Privy Council. This was a special leave against the judgment of the order of High Court of the Madras. So, to the session judge, there was the appeal to the High Court, from the High Court by special leave to the Privy Council. Now, the facts of the case are simple. Like in every village, there is fighting between two factions. Here also there is fighting between two factions, and the crime was committed at 6:30 p.m. on the 29th December and 7 a.m. on the 30th December. Then the police inspector held the inquest of the body of the deceased. Then the circle officer took the case and investigated thoroughly. Persons were arrested, and then they were charged of rioting and the murder. From the para number 8 onward, you will find important thing for our discussion. There were two confessionary statement made by the accused. One is on the para number 13 and another is on the para number 14. In the para number 13, there is the statement that about 14 months ago, I, Kottaya, and the people of my party lay in wait for Sivaya and other at about sunset time at the corner of Pullipad tank. We all beat the Buddhupati, Chinna Sivaya, and Subaya to death. The remaining person, Pulaya, Kottaya, and Narayan run away. Dondapati Ramaya, who was in our party, received blow on his hand. He had a spear in his hand. He gave it to me. I hid it and my stick in the rick of Venkatanarasu in the village. I will show you if you come. We did all this at the instigation of Pulukuri Kottaya. So the statement, this confessionary statement, though it is made to the police officer, so it is hit by section 25. But that portion of the statement, that I will show you where I hid the spear used in the crime and the stick used in the crime. The whole of the statement, except the passage, I hid it and my a spear and my stick in the rick of Venkatanarasu in the village. I will show if you come, is except this, all is inadmissible. in the evidence of witness Potla Chinna Mataya proving the statement of the accused number 6 that I, Mataya and other went to the corner of the tank land. We killed Savaya and Sobaya, that must be omitted. On the para number 15, I stabbed Sivaya with a spear. I hid the spear in the yard in my village, and I will sow you in the place. Now, in this statement that I will show you in the place, and in the consequence of that, when both the accused were, taken to the place, they have find the weapon used in the crime. Now the question is that what part or how much of the statement has to be used as per the section 27, and the High Court has, wrongly used, and there is the difference of opinion between two high courts. At one side there is Lahore High Court in the case of Sukam versus Crown 1929, and Gannu Chandra Kasid versus Emperor, the Bombay High Court, and the another side, in this case, Athappa Gundan. And so the appeal was preferred to the Privy Council. And the Privy Council has settled the controversy and said, these two para you have to read. One is this para number 10, that talking about 8 and 10, that talking about that how these sections were drafted, and then the use of these proposition in para number 16. In the para number 10, it says that section 27, which is not artistically worded, provide an exception to the prohibition imposed by the preceding section and enable certain statement made by a person in police custody to be proved. The condition necessary to bring the section into operation is that the discovery of a fact in consequence of information received by the person accused of any offence in custody of police officer must be deposed to, and thereby so much of the information as it relate distinctly to the fact thereby discovered may be proved. The ban was presumably inspired by the fear of the legislature that the person under the police influence might be induced to confess by exercise of undue pressure. So these few lines I have read, but you have to read whole para number 8, whole the para number 10, whole the para number 11, and the para number 16, where the controversy is settled that the so much of the portion of the confessionary statement that lead to the discovery of the fact that the weapon of the offense was lying there and the accused has the knowledge. Only that much of the statement is in. If that much of the statement, after that much of the statement, if the under section 167, already we have discussed in our earlier classes, if there is, after discarding the confession and relying only that much of the portion, if the evidences are sufficient to convict the person, then the High Court can convict, and so the case remitted back to the High Courts after clarifying the position, the true scope of section 27. So please guys read this case, these para number 8, para number 10, para number 11, and then at the last para number 16 you have to read. So with that, our today's discussion come at end. If you have any question or if anything has left in our next class, we will cover that portion also. With this, today class is over. I'm giving 1 minute to you if you have any query, question, etc. And with that, I will leave the meeting.